Thank you, Elizabeth, for being here with us today. One of the reasons I wanted to have you on is I kind of came into this late in the game. I saw you on social media, and I was just getting like bits and pieces of what's going on. And I would like to give everyone like the full picture of the entirety of SB 174. So with that said, what is SB 174?
Sure. Well, thank you for having me. Senate Bill 174, it's an Ohio bill. And what it basically is being sold as is a bill that would reform family courts, modernize the system, make things better for families, encourage parent-child relationships, and just make things better for families, which sounds amazing. Like people like myself who've been advocating for family court reform, that sounds like music to our ears. The problem is Senate Bill 174 doesn't do any of those things. What it really does is it maintains the existing structure, and it doubles down on the way that courts handle things. And we can get into the nitty-gritty. But basically what it does is it gives courts more authority, more power to do what they're already doing and expand their control over Ohio's families, even when dealing with fit parents who have done nothing wrong, and even if those parents are in agreement. So Senate Bill 174 is a horrible bill. It was written by judges, and it was written as a counter bill to bills that were written by citizens. And we were trying to bring reform, and the judges didn't like it. And so as a countermeasure to our efforts at the State House, the judges got together and wrote their own bill.
So it sounds like it's something that's really wholesome. And it sounds like it is something that actually supports parents and families, but you're saying it's the exact opposite. And it's in opposition of other bills that were written. So what were those other bills that were written, and what did they say for these judges to write this new bill that they're legislating?
Sure. So there was actually two very large bills that were introduced the last two General Assemblies. So two General Assemblies ago, it was House Bill 508. Last General Assembly, it was House Bill 14. If you were to Google either of those bills, you'll see everyone's focus on equal parenting. Those bills did establish a presumption that fit parents are going to have equal access to their children unless there's a reason they shouldn't. It's just a foundational principle that courts really shouldn't be involved in separating fit parents from children unless there's reason to do so. But the bill was way more than that. It was 200 pages, and it included a lot of things. It dealt with how courts should handle domestic violence, for instance. So law, as it is right now, already requires the courts to consider it. That was something they really did not want to do. There was very specific things that they came out to say in opposition to our bills, and the two things they really focused on was an equal presumption is bad, and tracking outcome of cases would be too costly for us as courts. And that was basically their main talking points. But again, there was a lot of things, including how they would handle cases, putting time caps on cases so they couldn't drag on for years and years and years, putting rules for guardian ad litems on how they operate. So our bills, and when I say our, it's because I did lead that charge, so I'm intimately familiar with the language of those bills. That also means that I was intimately familiar with the opposition, which are the judges and the family law attorneys in Ohio. So I have a lot of background in the bills that we proposed and then the counter bill, which is Senate Bill 174. They didn't like our bills at all. They did manage to kill both of our bills. Towards the end of last General Assembly, though, they threatened, basically, I call it a threat, they would not call it a threat, but they said that they have this bill and that they have a sponsor and it's going to be introduced any day. The bill that they got introduced, they dropped it at the end of last General Assembly. It was Senate Bill 325. Senate Bill 325 is the new Senate Bill 174. So it's the same bill, but they dropped it at the end of last GA so that this GA, they could just quickly get it introduced and push it through fast.
And so what was the point of actually changing that to, because 174 was getting so much negative publicity, and so why would they change it?
Well, 174 is still an active bill.
Okay.
So 325 was the precursor to 174. That was last General Assembly. The years actually leading up to them dropping their bill, they sent a copy to me. The judges themselves sent me a copy of this bill 3 years ago. So my team and I have actually been analyzing it for 3 years. So when we first started getting opposition to our bills, there were three main groups who came forward in opposition of our bills. It was the Ohio Bar Association, the Family Law Group, of course, or committee, of course, the Ohio Judicial Conference, which are the judges. I was new to advocacy 5 years ago. I had no idea who the Judicial Conference even was or how they operated. Obviously, now I understand. But they represent the judges. And then the Ohio Domestic Violence Network also came out in opposition of our bill. So first we tried to talk with the domestic violence group because we feel like our bill could have actually helped them in a lot of ways. But they didn't want to hear anything about it.
Why not?
They believe that if you have an equal presumption, abusers are going to get kids. It didn't matter that we were very particular about our language to make sure that that was a reason to rebut an equal presumption.
So what was some of, because I am interested in that part of it, and I guess one of the things that I want to differentiate between is that Senate Bill 174 is for fit parents. This is not for parents who have a history of abuse or there's been any type of abuse in the case. Is that correct? Is that what you're saying?
Senate Bill 174 is the current bill. That's the bill that was written by judges. That bill will make things way worse for families who are experiencing domestic violence. Mm-hmm. They are pitching it as good for domestic violence victims because there are some stipulations in there. They reworded the existing statute on the court must consider domestic violence and child abuse. That's already law. Okay,
Yeah.
So they reworded that a little bit, and they're patting themselves on the back for that. Courts already have to consider that, and they're not. So I don't know that would do much to help anybody, in my opinion.
Okay.
But the big problem here is that in a situation where there is domestic violence, the court still has ultimate discretion on what to do. So requiring that they consider domestic violence doesn't mean anything when they have the ultimate power to decide whatever they want to decide based on what they feel is best. Mm-hmm. So that's where you get into judicial bias, because at the end of the day, courts already have the authority to make a decision based on what they feel is best, with or without evidence. Senate Bill 174 increases that authority to something called complete discretion, which means there are no guardrails to what they decide they feel is best. So if you already have judges making erroneous decisions or putting children into abusive homes, how are you going to appeal that when they've now been gifted complete discretion to decide what they feel is best?
So would this 174, would it not even be a conversation if Bill, you said 508 and 14, if those had never even been presented, or was this something that they have been working on anyways?
So they will tell you that their bill is a result of decades of research and collaboration between multiple groups and attorneys and practitioners. They never list parents.
That's what I was going to ask. Are the parents on there? Are the families on there?
Yeah, but they'll claim that they've been working on this for decades. What they're pointing to is in the 90s, the early 90s, that's when our laws significantly changed for custody. That's when they established the best interest of the child standard. Mm-hmm. Okay, that's when the statute said, okay, from going forward, courts, you have to consider the best interest of the child, and here are the things you're going to look at. Okay, now there's a problem with that, but we can get to that later. But the best interest of the child statutes were created in the 1990s. Late 80s, 90s. Then in the late 90s, they recognized we still have a huge problem here. Parents are being sidelined. Parents are fighting. We haven't seen a decrease in the litigation and in the conflict between parents. So that's not working. What can we do? So rather than change the law, they created a task force. And they had the task force deliver them a report looking into family courts, how they operate, and identify some of the major problems that they're seeing.
And real quick, can I enter? Who's on this task force?
So the task force was appointees from the governor. There was members from the Ohio Supreme Court, basically all branches, the agencies, legal practitioners. I believe they were mandated to include parents, but when I looked at the list, I didn't see any just parents. But regardless, it was almost exclusively attorneys and judges when you really look through the list. Okay.
Interesting.
They did produce their report. So that report came out for the first time in 2001.
So they had maybe about 10-ish years for this task force gathering all this information.
Well, the task force was created in 1998.
Okay.
They delivered their first report in 2001.
Okay.
Nothing happened. Okay, it's 2025,
What did
and
the
our
report
laws
say?
have not changed. It definitely recognized that parents are being sidelined. It definitely recognized that there's a culture in which courts don't understand family dynamics, and that parent-child relationships should be encouraged more, and that we need to change our laws to reflect that. That having a sole custodian outcome is a source of conflict because parents are fighting to have that sole custody, and that courts should be helping to facilitate peaceful negotiations, mediation, things that would help reduce that temperature. I don't disagree with any of those findings or
So the report
recommendations.
sounds like it was pretty accurate.
Yep.
Okay.
Yep. Well, they did nothing with that report. The legislature did nothing. The laws have not changed. It's
Even
now
though they
2025.
created the task force.
That's right.
And this was a report.
That's
they
right.
got the report back,
Yes.
and they essentially ignored it.
That's right. They put out another one in 2005 that essentially said the same thing. Still, nothing for 2 decades. Here's where it gets dicey. So when we introduced 508, which was our first bill, we dropped that bill in November of 2021. We had our first hearing in March of 2022. When we introduced our bill, we had 61 co-sponsors in the House of Representatives on that bill. So it was incredibly popular amongst legislators. It wasn't a hard sell. It made logical sense. But once it got in committee, it went to the Judiciary Committee, or at the time it was Civil Justice. So it went in front of a bunch of attorneys. And the judges and the Bar Association pretty much runs the State House when it comes to legislation. Things I didn't know going in. Mm-hmm. They killed the bill. They successfully killed the bill. But we woke up the judges. So immediately, how they killed the bill, one of the ways they killed our bill, well, both of them, was telling people we have our own bill. Don't do that bill. Don't do the equal parenting bill. And they came out and testified against our bill, saying judges are doing a great job. They have a thankless job. You know, these people here trying to accuse judges of tearing children away from fit parents, that's insulting to us. And, you know, we don't need to change the laws, but there could be some improvements. You know, wait for our bill. We have a bill.
There were years worth of reports.
Yeah.
Actually looking at what was going on and talking to people and being involved. That was just, that's baffling to me that you create this task force and then the report comes back twice. Yep. And it's like, nah, we'll do something else.
They did nothing until we introduced our first bill. So then they're saying, oh, we have this bill, and it's based on 2 decades worth of work. We've been working hard on this bill for 2 decades.
Was there a bill yet?
No.
No.
So that's the funny part. So when you're introducing legislation and you're trying to get it passed, they have what's called interested parties meetings. And that is when the proponents or supporters of a bill will sit down with legislators and they'll bring in opponents into the room and you kind of discuss things and you try to come to an agreement or make some amendments that can make everybody happy. That's just part of the legislative process. Okay, that's called interested parties meetings or IP meetings. So when we had both of our bills, we had a ton of IP meetings, and you know who was always in our IP meetings was the judges and the Bar Association. Always, always, always. So that's how I have a lot of insider information about Senate Bill 174 specifically, because it came as a reaction, as a counter bill to our bills. I mean, they have even said that. The craziest part is the judge who was leading the charge, her name is Denise McCauley. She's now recently retired, I think, out of pressure, because I was running around saying sitting judges are writing bills. So she subsequently retired. But Denise McCauley isn't just any judge. She's the mother of our sitting Senate President McCauley.
So there's connections.
Yeah. So when last GA, when we were reintroducing our bill for the second time, House Bill 14, we were trying to find a sponsor in the Senate to introduce the same bill in the Senate that we were introducing in the House, because it just speeds up the process when you introduce the same bill in both houses, or in both chambers. So when we were meeting with senators, we were hitting roadblocks because Senator McCauley, who wasn't president at the time, was pitching his mom's bill instead. So we didn't end up with a sponsor in the Senate because he basically blocked it himself. And then eventually Senator Gavarone, and Senator Paula Hicks Hudson, both family law attorneys, introduced the bill on behalf of the judges.
Interesting. Okay. And so where are we right now? And I want to go back over some of the details with it, but where are we right now with this bill? What is it doing?
So it flew through the Senate. We did have 2 hearings in the Senate Judiciary Committee where opponents were allowed to speak. There were 46 opponents who sent in testimony in opposition to this bill, all citizens, all regular people. There were 0 testimonies submitted in favor of the bill from regular people. Do you know who the supporters, the proponents of the bill were? Of course, the Bar Association, the Ohio Judicial Conference, and the Ohio Domestic Violence Network. They only had to provide their testimony one time. We got 2 chances, but the second time we got a chance to speak, they voted it straight out of committee unanimously. So it was pushed through very, very, very quickly. I do have a team of advocates that desperately tried to get this bill killed in committee by explaining to the senators on committee how horrible this bill is, because and this is what I tell everybody, it is a bill written by judges for judges to expand their power over fit and loving parents. And it goes beyond just divorce. Their bill connects that complete discretion and all of these new rules on how they're going to determine custody and parental rights and responsibilities is going to transfer over to the juvenile courts where CPS cases are heard, or where unmarried parents' cases are heard. So this is going to affect anyone, because anyone at any point can be hauled in by CPS. So this is not just divorce, and it's very, very, very bad. I believe it is a stark contrast to what we were trying to do, and it completely destroys the concept of parental rights, because it's basically saying courts know best, even if you are not in conflict with the other parent, even if you have already decided how you want to raise your child together, it doesn't matter. Courts know best.
But they're not coming out and saying that that's what the bill says. They have kind of cute wording, maybe deceptive wording to make it sound like it's for parents, for the families. But like you said, as CPS is involved, they're part of the court, and they already have too much jurisdiction and too much discretion. And so it sounds like this bill just gives them even more.
Yes,
than
absolutely.
before.
Yes, all in the name of the best interest of the child. So if you go back and you look at the very first hearing we had for opponents, and there was a handful of us opponents who went in person to testify in person, the sponsor, one of the sponsors, Teresa Gavarone, was pretty hostile, I feel, to me and all the opponents who came to testify. But one of the things that she challenged me on is, because the whole emphasis of their bill supposedly is what is in the best interest of the child. Okay. The problem is the best interest is not defined, and this bill would only grant courts more authority to decide what they feel is best. Okay, so it's not a good thing, right? But she twisted it to try and corner me and said, well, what is more important? What's best for the children or what's best for the parents? Implying that it's a zero-sum game, that you can't look out for the best interest of children and respect parental rights. Right. Those 2 things, which I disagree with that. I believe parental rights are there for a reason. We are the natural caretakers of our children, and parents do have rights. And so their bill, I feel like not only is it insulting to parents, but I actually believe it's completely unconstitutional.
Yes.
So that bill, it flew through the judiciary. 4 business days later, it was on the floor and voted out of the Senate. So only 2 senators voted against this bill. It's a 400-page bill. There is no way that they read all 400 pages in 4 business days to be able to vote that way. So I started reaching out to senators, including my own. Why the heck did you vote yes on this thing? And the consistent replies that we're getting are, well, I was told that it's not perfect, but it's a great start.
Okay, so can I back up for a minute and forgive my ignorance? So there's a committee that this goes before first. How many senators are involved in that committee?
It's a very small portion. I think
Okay.
there's like maybe 6.
Okay.
All but one are attorneys. So it's the Judiciary Committee, and they intentionally beef up the Judiciary Committees in both chambers to be attorneys because the bills that are going to go before them are going to have to do with law. However, I do think in some cases that really teeters on conflict of interest. Legislators don't seem to agree with me on that. But I think as a citizen, hello.
Yeah.
I do think it is a stark conflict of interest when the 2 senators who introduced the bill, excuse me, are both family law attorneys. They directly will benefit financially in their industry and in their own practices if this bill were to pass.
Yes. So it goes before the committee. There's only 2 senators in there. They're both attorneys anyways. And so does that committee, are they the ones that take it back to the senators and say, hey, this is what's going on? Do they explain it, or is it just kind of a quick brief?
It kind of all of those things. It really depends on where they're feeling the votes might fall. So leadership, this is where leadership is critical, because if a bill is passed out of committee, so the job of the committee is to vet bills, right? To ask all the hard questions, to try to get to the bottom of concerns, and to make sure that, a bill has appropriate language. So that's the purpose of a committee. That's great. But when it passes out of committee and goes to the floor for a vote, there isn't a hearing for the rest of the senators or the representatives, depending on the chamber, to hear all the specifics of the bill. There's not a hearing for them to hear the evidence, the pros, the cons, to have an informed vote. It's up to the sponsors of the bill to tell their colleagues what's in the bill. And they just believe each other.
And so they're just relying on sponsors who are for the bill instead of hearing opposing sides. The sponsors come in and say, hey, yeah, this is great, vote on it. And so we have these senators that we put into office, and even though it sounds like the people's voice is to say absolutely no to this, do the senators not know that that's what the people are saying? Do they not care? Do they just do what's easy? I'm trying to connect why the senators, people that we put there who should know the voice of the people, why they're voting yes on this when it's not what we the people want. Is that something that can be explained? Is it ignorance? What is it?
It depends on who you ask. I have not seen but one senator come back and say it was a mistake. They tend to double down. Like my own senator, he replied with, oh, this would have been great information to know ahead of time, which I did stop by his office and ask for a meeting, by the way. Never got that meeting. But here's what we were told is why this is great, and, it is what it is. It's too late kind of thing. But what was interesting is the bullet points of things that he sent me as a justification are those pretty talking points that sponsors gave in their testimony.
Can we talk about some of those? Because
Yeah.
I would like to know what those are so people can understand what it actually means.
Yeah. So they keep it very high level. So one of the things that they say is that according to them, their bill would encourage parent-child relationships and frequent and continued contact. That is all existing law.
Correct.
That is already in there in like 4 different places. Okay? They reworded the same thing with the same effect. So
And why would they reword it? It's just a distraction just to make it extra long so nobody reads it? Why do you repeat it?
because it sounds good.
Yeah.
because when you have a bill, so when you're looking at a proposed piece of legislation, you can see they will have the whole section of the revised code, for instance. Like they'll say this is a law of section 310904. Okay. So they'll have like 310904. They'll have crossed out the parts that they're deleting.
And is that best interest?
No.
Okay.
But I'm just generally speaking
Okay.
about bills.
Mm-hmm.
Okay. So the part of this section they're deleting or changing will have a strike through line. There's just a line through it. And then anything new they're adding is underlined. So if you go on the website and you look at bills that are pending, and you're looking at a bill, if it's stricken through, that means those words are changing or getting deleted, and the words that are underlined is new language. So when we're talking about these talking points, these beautiful, it's so good for families, it's going to encourage these parent-child relationships, if you look at the bill, they're all underlined because they've reworded it. So it looks like it's a new thing they're adding, but it's not.
And so can we have an example of what was said, what was a strike through, and then what is underlined underneath it?
Well, that's what I'm saying. So here's a tricky thing they did with this bill is they actually repealed, they struck through the entire current 310904, which is dozens of pages long. And then they wrote a whole new section to replace it. So it's not a side-by-side comparison.
Interesting.
Yeah. So you got to dig.
Yeah. It's not easy to follow.
No, no. That's what and I think that they rely on that. You know, their problem that they have right now is the opponents like myself have had this thing for 3 years. Like my team analyzed this thing 3 years ago, and they've made some tiny tweaks to it. They made some tiny amendments to it, even in committee. Nothing that would change the substance of the bill, though. But their problem is we know the bill better than they do. I don't even think the sponsors know the bill. Because they didn't write it. The judges wrote it.
So why are the sponsors so interested then?
I don't know. I can't speak for them, but they are family law attorneys.
Okay.
You know, and you have the Senate president pressuring someone to pick up his mom's bill.
Mm-hmm.
You know?
Yeah.
I don't know. Politics.
Yeah. It's interesting. One thing I'd like to talk a little bit about is best interest, because you said that this bill is actually based in that. That's the foundation of best interest of the child. And that's what most family courts are supposed to base all their decisions off of. So let's talk about best interest and what that is and what it actually means and what kind of guidelines are there.
Sure. So the best interest standard, I like to say it's not an actual standard because all it is a list of criteria to consider. So the best interest of the child standard does not tell courts what to do.
So it's not a standard, it's a consideration?
It's a list of considerations.
Mm-hmm.
So the outcome is entirely dependent up to the judge. That's current law, and it's been like that for decades. That's why everything is a mess, in my opinion. That was one of the things we were trying to remedy in our bills, because the current best interest of the child standard is not a good standard. It isn't even a standard. It leaves way too much up to the judges to decide. So a judge's personal bias, they have to apply it because there's nothing in the statutes that tells them what to do. The best interest of the child does not tell them what to do. It just tells them you have to consider these factors. And once you consider all the different factors, so some of them are the wishes of the parents, where are the parents living, has there been domestic violence or child abuse? Like those are all factors that the court has to consider. But there's nothing to tell the courts what to do with that information. There's nothing to guide courts on what they're supposed to do.
Right, because every situation is going to be different. Family dynamics are different. There's not one set rule to look at because no one's going to be the same when they go into family court. And that sounds like that's where one of the huge problems are, is it's open to interpretation of that specific situation.
Yeah, but they will say they need that discretion because every family is unique. So they'll say, but we need it to be open-ended because no two families are alike. Mm-hmm. So they're like, we're saying because it's so open-ended and no family is alike, that you can do whatever you want, and that's a problem. The judges and the attorneys will say, well, no, because no family is alike, we need the power to decide what we feel is best. Mm-hmm. Okay? And that's already current law. The problem with 174 is it expands that power to courts can create their own plan. See, right now, parents have to submit a plan. And the court can look at their plans and decide if the plans that the parents have submitted is in the best interest of the child, which is still problematic because, again, best interest isn't a standard, okay? But under current law, they can't just create their own plan. This bill, Senate Bill 174, allows them to create their own plan over the judgment, even the agreed judgment of two fit parents.
So you're saying that if two parents, and we're not talking about toxic, narcissistic, controlling, vexatious litigants. We're not talking about them. We're talking about two fit parents who maybe don't agree with each other but love their kids. And so they get together, and they say, okay, we can at least agree upon shared parenting this time, these days, and then here it is. They present it before the judge, the magistrate, whoever. And right now, the way the law is typically the judge, the magistrate will agree with that. And so you're saying that with this new Senate Bill 174, that if this goes into law, that judges can do whatever they want, magistrates can do whatever they want,
yes,
no matter what the parents want.
Yes. That's
so
why I believe it's
parental rights are being taken away with this bill.
Yes, that's why I think it's completely unconstitutional. And by the way, I'm not an attorney, but I'm not the only one who feels that this bill is unconstitutional. So quickly back up on the status. So it went out of the Senate and went over to the House of Representatives. It's been assigned to the House Judiciary Committee. One of the members on the committee is an attorney. His name is Representative Josh Williams. He has come out publicly as an attorney opposing this bill strictly on constitutional grounds.
Good.
So we are getting opposition in the House that we didn't get over in the Senate. No one wanted to push back to the judges in the Senate. No one wanted to push back to Senator McCauley in the Senate. But in the House, at least, we have a few good men who are willing to say this is garbage.
So why is Josh Williams, why is he saying that it is unconstitutional?
Well, because there's over 100 years of Supreme Court precedent, U.S. Supreme Court precedent that protects parental rights, that basically says that parents are presumed fit and that fit parents are presumed to know what's best for their own child. This bill gets rid of all of that Supreme Court precedent. It's completely unconstitutional. It basically says that it doesn't matter if you're fit, courts know best.
Right. And I've looked into this a little bit, and that's why we have our Constitution. That's why we have the 14th Amendment, which is due process. I'm not an attorney either, but since all of this, I've been really digging into it. And what I found is there are actually 3 different Supreme Court lawsuits of parents going to the Supreme Court, having to go to that appeal because their parental rights were being violated. And once it did hit the Supreme Court, they said, you are correct. Your parental rights were violated because of the 14th Amendment. And so if that's really what's going on with this bill, is that not going to create all kinds of federal lawsuits against our own state, against our own counties? I don't see how it couldn't. If people are aware of this and they understand what due process is, they understand that the Constitution actually protects parental rights, then to me it seems like you're opening a can of worms that it's going to get chaotic more than it already is. Is that accurate? What are your thoughts on that?
I definitely think it opens the state of Ohio up to lawsuit. I am skeptical on lawsuits in general because you have to have a lot of funding to do that kind of thing. So the average parent doesn't have that kind of resource. I mean,
just can't afford it.
Yeah, just simple as that. Especially if you've been going through it for years, how are you going to do that? And good luck finding an attorney that you can afford who will do that because they're basically taking on the judiciary. And it's hard to win on appeal anyway. It's really the reason there are so few cases that have made it that far, even if people are trying, is because they tend to be just, ignored in the lower courts. I mean, the courts have, your local courts already, the trial courts, have a lot of discretion. They already have a lot of power. And so, if you try to appeal a decision, based on parental rights even, like they violated my due process rights or my parental rights, it's hard to prove that because even at the appellate level, you have to show that they abused their discretion because at the end of the day, they have discretion. So if you can't show that they abused their discretion, it's hard to win on appeal anyway. So it's never going to go past that, and most don't. Okay? This bill expands their power to complete discretion, so good luck on appeal. How are you going to prove that a court abused their discretion when their discretion is limitless?
Yeah, because there's no foundation to even base anything on at that point. If it's just discretion, then it's open to anyone's interpretation.
Yes, right.
So, gosh, my mind's just spinning because I think, what a mess
Yeah.
this is about to be. So,
yeah.
So what can be done? to stop this bill?
So right now, we're really trying to get the bill killed in the House. In order to do that, we really have to rally not just citizens. We need masses, but we've seen in this General Assembly alone where the voice of the people has been ignored, even a loud voice of the people. So it's really hard to get anything done, even if you have a lot of citizens, but we need it. But what we really also need is some influential organizations to come out and say, whoa, because at the end of the day, who pays most politicians' bills? You know what I mean? Like, where does their campaign funding come from? It's not the $20 that you and I give. It's not the $100 dinner fee that you pay to go to an event. They have donors. So what we need is people that work for these donors, these organizations, to come out and say, whoa, we're coming into an election year. Like, there needs to be some serious, reprimands for the senators who voted this thing through without reading it. And then there needs to be some accountability, even preemptively, for the representatives to ensure they don't support this bill.
Mm-hmm. And so the donors are kind of, it sounds like what you're saying is they're the ones that we need to go to. They're the ones that have more influence than even the people do. No matter how many of us there are that say no to this, we've got to get with donors. So do you know of any donors who are saying no to this bill?
Yes. So there publicly we have Highlands for Medical Freedom. Moms for Liberty has come out. National Parents Organization, Ohio Family Rights. There is a conglomerate group of people that are either representing parental rights organizations or representing conservative values. I do not believe that this is a party issue. This bill was bipartisan. So this is not a Republican versus Democrat issue, but it does seem, at least right now, most of the groups that are coming forward to speak against this bill are conservative groups, mostly because they're the ones who are most engaged in conversations around parental rights. But any group, I think, should really take a look at this bill and understand what the implications would mean. I mean, it's far-reaching. Imagine you have come up with an agreement with the other parent where you don't want to vaccinate your kids. And that's extreme, but as an example. And the judge just feels like, well, that's not in the best interest of the child. So then they order the child to be vaccinated. That is what this bill would do.
Interesting. They can even... So best interest is anything.
Yes. And they've expanded the list of considerations. So there used to be like 15-ish. Now there's like 25 in one section, 35 in another, or 10 more, so like 35.
Like what best interest could mean?
Not best interest, but the things they can consider.
Okay.
So remember, best interest isn't defined.
And it started off with 15 and now there's about 35?
Yeah. And they've added things like the disability of the child or the child's developmental age, the parent's work schedule, the parent's ability to work and get the child to their extracurricular activities. So think about this. You have parents who are working, paying the bills, taking care of their children, but they might have grandma, grandpa take the kid to soccer practice after school because they're not home from work yet. The court can absolutely use that as a reason to restrict their parental rights.
Interesting. So I'm just thinking about, let's say you have a parent who, and we all know plenty of people are like this. There's parents that go in who they truly love their kids. They truly want the best interest. And then there are people that go in who they just want to control the other parent. And so that's why they're in court constantly. It's a control issue. So what does this do for parents like that are these toxic personality types? How will they be able to use this new law to kind of benefit them, to help control over the parent even more than they already are? What are your thoughts on that? Because that sounds pretty alarming.
Yep. So one of the new statutes that they're adding is that the court can order basically unlimited evaluations and investigations into a parent. So right now, courts can still order like your psych evals or your financial analysis and things like that. They already have that authority. But what this bill would expand that to, they can do it at any time. So right now, they only do that in preparation for a trial. If like mediation's not working, if y'all are clearly not going to come to an agreement, and this is going to trial, well, if this is going to go to trial, then we're going to need to involve a guardian ad litem, or we're going to need to involve a psychologist, or we're going to need to involve all these other people, right? And this bill allows them to order all of those tests, and it even says at the parent's expense, without limit, even when not going to trial, even if parents are in agreement.
So I guess the word that just alarmed me that you said is without limit.
Yeah.
Is that wording actually in the bill?
No. So it says courts can order evaluations, investigations at any time during the trial or during the pending case at the parent's expense. So there's no guardrails on that, you see.
Right.
Because there's no guardrails, that's why I say it's unlimited. Because there's nothing that says only for trial. There's nothing that says a limit on how many they can order. So if there's nothing that gives them any limits, there are no limits.
So this is like a narcissistic, abusive litigant's dream come true.
Oh, 100%. And the attorneys who make a lot of money on it.
Yes.
Yeah.
Yes. And them too, because it's just a revolving door at this point.
Yes. All done in the best interest of the child.
Which is broad and open to interpretation of whoever wants to do it. And one magistrate, one judge is going to interpret that completely different even than maybe your neighboring county.
Oh, absolutely. Well, they're already doing that. So current law requires that every local court, every county essentially, has to come up with their own local parenting time rule. So it's their fallback. So if parents can't come in with an agreement, what is your presumptive fallback going to be? A majority of Ohio counties, their fallback is an every other weekend for one of the parents. We do have some counties in Ohio that they start at 50-50. Then there's counties that are kind of in the middle. But it's up to each county what they want to do. Mm-hmm. But the criteria they're given is to create a local parenting time rule that is in the best interest of children. So why do we have 88 different rules that are all in the best interest of children?
And what also I'm hearing is that, as my mind is just spinning, there's no, and I know you've used the word accountability a few times, but this allows possibly extreme decisions without any type of accountability as to why the judge, magistrate, whoever came up with that decision to begin with. Because to me, it seems just to say, okay, this is why we've made this decision, give all the evidence, here it is. But it sounds like they can just say it's not in best interest, so this is what we're doing anyways. And they don't have to really explain themselves.
So that's current law. Actually, in current law, they do have to explain themselves if they're going to put children in the possession of someone who has a conviction in child abuse or domestic violence. They actually do have to provide those already. They don't. Shocker. They don't already follow the law, people. So giving them more authority is not a good thing. Their bill actually that was one of the amendments that they provided. So they did amend the bill to say that courts do have to provide their findings. That is a good thing, but it doesn't mean anything when ultimately they still have the discretion, the complete discretion to decide what they think is best. So putting all the facts of the case and the findings of the case in the order, that is important. We definitely want that. But they're not going to still get in trouble for their decisions because they still have the discretion to make the call. Mm-hmm. You know what I mean? So facts and findings are important, but they don't mean anything when the courts have unlimited discretion, you know?
Right. And so when I think about this bill, I just see, I just like blurred. There's nothing that's really concrete that we've talked about and definite and something that parents can use as backing. It just seems like it's just this cloud of questions and cloud of chaos. Like, what is going on with this? It's hard to believe that our senators passed this bill. It's really hard to believe. And to me, it's kind of demoralizing knowing that we put those people there. And here we are saying this and saying why, and it makes you think how many other bills are getting passed. They have no idea. They're just told by the interest groups, this is great, and so they go with it. That's extremely alarming.
I think that's a majority of bills.
Yeah, that's not okay.
Mm-mm. The most alarming thing to me was actually two things in the process besides the bill itself. Throughout the process, the two things that stood out the most to me is one, that judges walk the state house, that they meet with senators and sitting judges, and they meet with representatives, and they lobby them on bills. So the thing about the Ohio Judicial Conference, which I'd never heard of before, first of all, they were created by the legislature. They are an organization that is tax funded.
Interesting.
It's in our budget that we pay the Ohio Judicial Conference. So I was like, well, who is this? Because all of our meetings, it was actual literal judges meeting, like coming in all these different meetings, like sitting judges from all over Ohio, sitting down with us to talk to us about our bill at the time. I'm like, why are all these judges involved? Who is the Ohio Judicial Conference? And then I was like, oh my gosh, they're taxpayer funded. They're a line item on our budget.
Yeah, I've never heard of this either until I started talking to you.
Yeah. So then I went to representatives, budget times, like, guys, why are we funding these people? They're judicial lobbyists. They're lobbying. I mean, that's what they're doing. They're lobbying. They came out and testified in favor of their bill and against our bills multiple times. Sitting judges left the bench to come to the State House to testify in committee. So I think that's a huge separation of powers problem in and of itself. So I started asking questions of who is the Ohio Judicial Conference, and the representatives are like, well, they're actually legislatively created. Like, we created them. They have a job. And so I was like, oh, well, what is their job? So they were created to provide fiscal analysis reports. So basically, if there's a bill that would impact courts, they have to come back and say, listen, if this bill passes, we need extra money in the budget to help fund these changes. It's going to impact courts like this. It's going to, we're going to have to hire more magistrates. We're going to have to hire more data people, whatever. They have to report the fiscal impact of a bill, which is fine.
Right.
I think that's, for taxpayers, that's important that we know what the cost is for changing things. I have no problem with that. But that's not what they're doing. They didn't even provide fiscal reports for the bills of ours that they came out and testified against. Like, they're not even doing their job. They're just lobbyists.
To keep them accountable for that. Like, that was their job, but it's not being done, and so they're doing something else.
Absolutely.
And
yeah.
Who's to keep them accountable for writing their reports?
It's supposed to be the legislature. The job of the legislature is to keep these checks and balances. That is their job. So the Judicial Conference is not only not doing their job, they're taxpayer funded, but this GA, they have 4 full-time taxpayer funded lobbyists. Like, they actually are listed as lobbyists. So we knew all along they were lobbying based on their behavior. But now they're officially on the record. You could go right now and look through the list of registered lobbyists at the Ohio State House, and there are 4 full-time registered lobbyists that work for the Ohio Judicial Conference. So taxpayers are funding judicial lobbyists, and they got their budget almost doubled this GA.
So that's where my thoughts went. I'm thinking, we're saying no, but we're paying people to say yes.
Yes.
Even though that's not what we want.
Yes. So when I started, and then the kicker on that is my team and I were talking with legislators about this last General Assembly because they were interfering in our bill so much. So we're the ones who started talking about OJC not doing their job and acting as lobbyists. And so we tried to actually get their funding cut. And there were some representatives in the House that were helping to try and get their funding cut because they're not doing their job. And they're judicial lobbyists. Well, leadership came back, and not only did they not cut their budget, they doubled their budget. Almost but doubled.
After there was complaint about it?
Yes. Yep.
And what was the reasoning for doubling it?
Oh, well, we don't know that.
Did you get one?
No. No
reason. Oh, gosh.
I mean, leadership has not met with myself directly.
They won't do it?
We've had multiple requests. They've never met with anyone on my team or myself directly. So a lot of what I know leadership has done has come through representatives and senators themselves. So you could probably call that hearsay, I guess, but the proof is in the pudding.
Yeah.
But no, I never heard why they raised the budget, but I do know there were representatives trying to cut their budget.
Okay. So as we finish up here, what's one thing maybe that we did not touch on that you would like people to know, to be aware of?
This is a huge mountain to climb because there are special interest groups and lobbyists whose full-time job is to lobby bills. It is hard for us to compete I'm just a volunteer. Like, I don't get paid to do this. I just really care.
Mm-hmm.
And the more they fight me, the more fight it puts in me. So I just won't go away. I'm this annoying woman who just will not go away. But we have to be loud, and we have to start thinking bigger. If you are part of a group or an organization, even a local group at your church, I don't care. We need groups of people to stand up and say, parents have rights. Children need their parents. The courts do not know best for our children, and the courts do not need more power.
Right. It makes me wonder, too, how many of these people have ever actually personally been involved in family court. And if you haven't personally been involved in family court, you don't know the pain. You have no idea.
Yeah.
And so to lobby for something and to pass bills about something that you have, it's your profession, but it's not your personal life. You go home at the end of the day and sleep well and have great vacations.
Yep.
But you've never personally experienced it and the pain with it. And so that's also baffling to me that these laws can be passed by people who really don't understand what it means personally, because family court is extremely personal. It's not, criminal court's obviously personal too, but not like families are, intimate. And so it's really frustrating and sad to see that power is given people who don't even personally know the pain that it is.
Yep. And it's easy to write parents off, because sometimes we do act irrational when you threaten to take our children, or you do take our children. What if we're not mad about that? What are we going to be mad about?
Right.
You know what I mean? That's the time. That's the time to care. Mm-hmm. But that because caring is viewed on negatively, because they want court to be a transaction. They don't want emotions in the courtroom. Like there's a judge on TikTok, an Ohio judge on TikTok, who has a whole channel talking about how things work in his courtroom and advice to parents that he gives. And in one of his TikToks, I couldn't believe it. He said, if you come into my courtroom, I'm looking at you. I'm looking at how, what you're wearing. I'm looking about your facial expressions. I'm looking at how you're acting in my courtroom. And if you're coming across as a jerk, and I'm going to take that into account. And I'm like, this guy obviously does not understand human behavior.
And he puts it on TikTok?
Yes!
Do you know the name of this judge? Not that I want him to get any views or anything, but that's incredible. And not in a good way.
I know. And funny
it's
thing.
It's just blatant.
Yes. And not ashamed about it at all. No.
No one's told him, hey, you shouldn't be talking like that as a judge on TikTok for everybody to see as entertainment.
No, we tried to report him. And actually, interesting too, all the judges who've taken effort to come and lobby for bills, we've actually put in judicial complaints against them because we feel like it's a violation of their oath, separation of powers, all kinds of things. All of those have been rejected.
And who are those complaints going to?
So if it's a judge, it can go to the Disciplinary Council of the Ohio Supreme Court. So judges judging judges. Mm-hmm. And then, or you can file a bar complaint, and then it goes to the Bar Association, and the Ohio State Bar Association then decides if their behavior was good or bad. So you have attorneys judging attorneys, judges judging judges, and they tend to protect their own. I mean, it's really, really difficult to get a grievance accepted and investigated. A vast majority of grievances are just rejected, including all of ours.
And you've gone to both.
Uh-huh.
Mm-hmm. Mm-hmm. Okay, so what can we do? What can people do? You said get involved in groups. For this podcast, I'm going to have links in the description. What links are we putting in the description? Where can people go to talk to their representatives? What's the best thing, if you're not involved in a group, to be doing right now?
I think we really have to kill this bill. That is priority number one. I'm still working on reform. I'm still working on other bills in the background. But priority one is to kill this bill, because nothing else will matter if this passes, But so to do that, if you are in Ohio, go to ohiosenate.gov or ohiohouse.gov. You can write on the homepage, enter your name and your address, or not even your name, I think just your address, and it'll tell you who your senator is and who your representative is. It'll take you to their page, and you can send them a message right then and there. It's really easy to do, but you need to find out who your senator is and who your representative is. Focus on your representative, because they haven't voted yet. So find out who your representative is, message them, call them, try and set up a meeting, because I'm telling you, they listen to the squeaky wheel, and especially a squeaky wheel in person. Lobbyists are there in person every day. Mm-hmm. Every day they see these faces. They make friendships with these lobbyists. They like them. They go out for drinks. I was in the middle of a meeting with a legislator once, and they left in the middle of the meeting because, oh, sorry, I got to go. There's a lobbyist convention downstairs.
Oh, wow.
So literally left a meeting with me, a regular person, to go to a lobbyist convention downstairs.
So they have a loud voice, the lobbyist.
So get to know your representative personally. I actually connected with mine by just going to an event, and he was there, and he actually recognized my husband, which is a whole different story, but because my husband had tried to reach out to him, but he recognized my husband. So then when he was at that event, we just connected in person and then built a relationship from there. So you don't have to be involved in politics to meet these people. They're just regular people. Don't be scared of them. Mm-hmm. They are just regular people, and they have a lot of bills to consider. They have a lot of work to do. So the best thing you can do to be heard is get to know them personally, and don't be afraid of them.
So you said go to events. Like, me coming into this, it's all new, and you hear about these things, but when it becomes really personal, then it's like you start digging in. So where are these events? How are you finding them? How, you said in person is best. It's still an email through the website is still good. So if someone is timid about that, where in events where people are at, it might be a little less intimidating than one-on-one. How can we find where they're going to be?
A lot of them have social media. So if you can find out who your representative and senator are, a lot of times they'll say on their social media where they're going to be. Follow their web pages, because their campaign pages will often tell you their schedule, where they'll be. And if they're in your local community, sometimes, mom and pop store is so excited we have a grand opening and we're excited that our representative is going to come. Just follow them on social media, basically. Figure out where they're going to be and just go. Yeah. Especially in a public setting, they're not likely to blow you off. You know what I mean? Because it's public. So they'll likely at least listen to you. And your goal there is not to pitch crazy ideas, but put little bugs in their ear and introduce yourself so that when you follow up via phone or email, they already know who you are. Mm-hmm. Because that personal connection is what's going to get you actual meetings that matter, Okay.
And this is all good to know, and you've been in this for quite some time, and so you can give all these little tips. So we'll put your contact information in the description as well so people can get in contact with you. And I would love to keep seeing your social media give tips like that. Just realistic, practical ideas that people can do that's within their power to, start making a difference. And then last question is, when is this bill going to be voted on? We didn't talk about that.
So it just got assigned to Ohio House Judiciary Committee a few weeks ago. They're on Christmas break right now, so they won't come back until January. So the earliest opportunity for a hearing would be in late January, mid-late January. That first hearing, and it'll be in committee. That first hearing will just be the sponsors coming over and giving their spiel. And then there'll be subsequent hearings where opposition will get to go, proponents, supporters will get to go, and then they'll vote out of committee if it gets that far. Most bills get killed in committee. If they're going to die, they typically get killed in committee. I don't anticipate this one will get killed in committee, even though representatives want it to. I just don't trust that it will. Yeah. Because there's too many statewide high-level leaders that support the judges that I really have a hard time believing that they're going to kill the bill. But maybe they will and surprise me. But if it makes it out of the committee, it'll follow the same path as the Senate. It will then go out to the floor, and that's when all the other representatives will have a chance to vote on it. That's why connecting and building a relationship with your representative is so critical now, so that when we know it's going to the floor for a vote, we can really tell them what we want them to do for us.
Okay, so it sounds like we're a few months out from it, so we have a few months to get really proactive and start taking
I would say a matter of weeks.
About it.
I would say a matter of weeks because, first of all, we don't know exactly when they will schedule committee. It could come as early as mid-January. We have no notice right now. We don't know. So testimonies, though, have to typically be turned in 48 hours in advance of a hearing. Sometimes they only give us 72 hours notice. So what happened the first time in the Senate committee is they put out a notice Friday night that wasn't, but it didn't post publicly. So you had to be on the page. So luckily, someone on my team was monitoring their page, so because the public notice didn't go out. But
Does it usually go out?
Yes, it usually does. But yeah, it did not. The public push notice didn't go out, but it did go on the website. So one of my guys saw it, informed me. So this is a late Friday night, but they were due Tuesday morning. I'm sorry, Monday morning. Monday morning, because the hearing was on Wednesday, 48 hours notice. So we had to rush to get testimonies because they could only be uploaded through the website, and you have to do it, sufficiently in front before the hearing. That is a common tactic to get fewer testimonies because people can't scramble to write a testimony that fast if they're not prepared. So here's what I'm telling people. Write your testimony now. We may have a few weeks before we get a hearing. Write your testimony now, because when we get notice that we can testify, we might have hours notice depending on when it trickles down to us. You know what I mean? And so have it ready so that you can just upload it.
And when you say testimony, it's all the reasons why we want no on this bill.
Yes.
Okay.
Yep. Or I guess if for some reason you support it. Right. But that's just generally how bills work. So it doesn't, that's just good information to know. But in this case, they are pushing it so fast. If you don't have your testimony ready, I'm really worried that enough people won't get their testimonies in.
Okay. And it sounds like they may not send it out publicly again as well.
Yeah. I mean,
we don't know.
Yeah. They're supposed to. It could have been a glitch in the system. So
Okay.
I don't want to imply something insidious there. But
Right.
we might not have a lot of notice.
Okay.
And so the only way to prepare for that is to have your testimony ready to go. It doesn't have to be fancy. It's just basically a letter, of how you feel and how you want the committee to vote. Tell them what you think and how you want them to vote. And you submit it online, and then you check if you want to deliver it in person also.
Okay. I mean, it sounds pretty simple enough.
It is.
Yeah.
It is. It's just a
Take some time, but it's simple.
Yeah.
Okay.
Yep.
Okay, well, that's good. And we're going to have all your information so people can follow you and ask questions and, hopefully really draw some awareness to this and get it shut down.
Yeah,
is
for sure.
what we need.
Yeah. We just need more citizen advocates.
Mm-hmm.
People don't know how things work.
Right.
It's different than I always thought.
Yes.
And it's not until I got in there and I'm seeing behind the curtain that I'm realizing, wow, this is totally different than I thought. And we're not going to be heard unless we know how it works.
Mm-hmm. Well, I appreciate you bringing awareness, and, let's do what we can to get it shut down.
Awesome.
All right. Thank you, Elizabeth.
Thanks.